5 sections. Every single CS executive batch gets these wrong in exams. Not because they don't study, but because these sections are designed to be confused with each other. If you're prepping for CS executive, this video alone could save you 10 marks. If you're a CS executive or CS professional student, or even a working professional who never fully cleared these up, this is for you. I'm covering 5 pairs of sections students constantly mix up, what the actual difference is, and the one line trick to remember which is which in the exam hall. Mistake number 1. Section 164 versus Section 167. First one. And this trips up almost everyone. Section 164 is about disqualification of a director when someone is not eligible to become or continue as a director. Section 167 is about vacation of office when a sitting director's office automatically falls vacant because of something that happened. Here's the trick. 164 asks, can this person be a director at all? 167 asks, has this specific director's seat just become empty? Disqualification can trigger vacation, but they are not the same test, and examiners love testing that difference. Mistake number 2. Section 185 versus Section 186. Second, loans to directors versus loans and investments by the company in general. Section 185 deals specifically with a company giving loans, guarantees, or security to its own directors or entities they are interested in, and it's tightly restricted. Section 186 is broader. It governs loans, guarantees, and investments the company makes to any other body corporate, subject to board and shareholder approval limits. Trick to remember: 185 is about insiders, your own directors. 186 is about outsiders, other companies. Students lose marks mixing up which limits and which approvals apply to which. Mistake number 3. Quorum for board meetings versus quorum for general meetings. Third, quorum. Board meeting quorum is governed under Section 174 and general meeting quorum falls under Section 103. Two completely different tests with different numbers depending on company type. Students blend these because both use the word quorum. But board quorum is about directors present. General meeting quorum is about members present. Check the current numbers for private versus public companies before your exam because this is a guaranteed 1-mark question almost every attempt. Mistake number 4. Independent director conditions. Under Section 149, fourth, Section 149 and who actually qualifies as an independent director. Students memorize that an independent director needs no pecuniary relationship with the company, but forget the specific exceptions and the cooling off periods for former employees or relatives or promoters. The trick? Don't just memorize independent equals no relationship. Learn the exceptions to the exception. That's where marks are lost, not in the general definition. Mistake number 5. AGM timelines. Under Section 96, fifth and last, AGM timing. Students know AGM must be held every year, but mix up the specific rules for a company's first AGM versus subsequent AGMs and the maximum gap allowed between two AGMs. This is a classic state whether true or false question. And the answer almost always hinges on whether the question is talking about the first AGM or a later one. Congratulations! You've just revised 5 of the most commonly confused provisions under the Companies Act 2013. Now here's my suggestion. Don't just memorize these sections. Understand the difference. That's exactly how ICSI frames practical and MCQ-based questions. If this lecture helped you, hit the like button, share it with your CS friends, and subscribe to Corporate and Securities Law Compass for the complete Companies Act 2013 masterclass. In the next lecture, we'll continue with another set of frequently confused provisions and practical exam-oriented concepts that can make a real difference to your score. Until then, keep learning, keep revising, and I'll see you in the next lecture. Happy learning! Welcome to Corporate and Securities Law Compass. I'm a member of the Institute of Company Secretaries of India, ICSI, and currently serve as a company secretary. The views, opinions, interpretations, and explanations shared on this channel are strictly my personal views and are provided solely for educational, academic, and informational purposes. They do not represent the views of my employer, any organization with which I am associated, any client, or the Institute of Company Secretaries of India, ICSI. The content is based on publicly available laws, rules, regulations, judicial pronouncements, and regulatory materials, or on hypothetical examples prepared for educational purposes. No confidential, proprietary, or unpublished information is used or disclosed. This channel does not provide legal, tax, financial, accounting, investment, or other professional advice. Viewers should consult qualified professionals before making any legal, business, or investment decisions. While every reasonable effort has been made to ensure accuracy, laws and regulations are subject to change. Accordingly, neither I nor this channel accepts any liability for any loss or consequences arising from reliance on the information presented. All trademarks, company names, and logos belong to their respective owners and are used only for educational, commentary, and informational purposes. Copyright Corporate and Securities Law Compass. Navigating Law with Clarity. All rights reserved.